Thank you very much for joining us for today's webinar. My name is Dustin Saldarriaga, and I'm a senior associate at Scott Legal PC. Today, we're going to spend some time talking about a very important topic that's been in the news a lot lately, which is layoffs. And obviously, a layoff is challenging for anyone who experiences it, especially if you're in the US on a visa. And so our presentation today is really going to be focused on what options are available to you after you've experienced a layoff. And our hope is that after this presentation, you'll see that you may have more time than you were expecting, and there may be options available to you that you may not have been aware of. A few things before we get started. Our firm is a full-service immigration firm, and though we do focus on business immigration visas, we also do practice family immigration law, humanitarian immigration law, really any form of U.S. immigration law. So we welcome any and all questions, even if they are outside of the sphere of business immigration. We will be continuing this webinar. We aim to do at least 2 webinars a month, and we do them on a variety of topics. At the end of this webinar, we will be sending out the PowerPoint that you see on your screen, as well as a link where you can sign up for our future webinars. And you'll also see in that email a link to our YouTube channel. We post our webinars to our YouTube channel, and we also post shorter videos, and these are all on a variety of topics. So please do check those out. We're very fortunate to have our managing attorney, Kelly Weiner, with us today. And Kelly will be, she has vast experience in a variety of areas of immigration, including the visa options and really the different pathways that we're talking about today. If you do have a question, please share it with us through either the chat function or the Q&A function on Zoom. And finally, our webinar will be recorded and will be made available. You'll find a link in your follow-up email as well. So without further ado, I will pass it off to Kelly.
Thank you, Dustin. Perfect. So so as Dustin mentioned, layoffs are always a challenge. It's and particularly so if you're here on a visa and now you need to figure out, okay, what is my next step? So in this presentation, we're going to talk about some things, some options that are available to you, some things you can consider. And it's very important to start planning right away. You can speak to your HR department. They may have some resources for you. And also, maybe a good idea to speak independently with an immigration attorney just to go over all your various options. So let's dive in. All right. So I think the first and most important thing you want to figure out is, if you are laid off, check your I-94. When does it expire? If you are in E1, E2, E3, H-1B, H-1B1, L-1O, or TN, you may be eligible for a 60-day grace period. So this grace period, the way to figure it out is it's the shorter of 60 days or the remaining time on your I-94. So let's say that your I-94 expires in 30 days. Unfortunately, that means you only have a 60-day grace period. Let's say your I-94 expires 2 years from now. You still have 60 days is the maximum amount of time that you can get. So that 60 days, there previously were no grace periods. And then in 2017, there was some changes to the regulations that provided these grace periods. And the purpose of them was to allow people in the circumstance where they've been laid off unexpectedly, or even if they've resigned unexpectedly, any situation where the employment has ended, earlier than anticipated. This grace period is meant to give you time to essentially plan and make your next move without violating status in the U.S. So it's important to know that work is not permitted during the grace period. So, you would need to have some type of approval for another visa, or we'll talk about H-1B as well. So you cannot just work during this grace period, but you can file a change of status. And we'll talk more on the next slide. But, if you're on an H-1B, you can potentially port. So let's move to the next slide. All right. So I think, when we talk about, the layoffs, especially that happened recently, we know that a large chunk of people are on the H-1B visa. So we wanted to devote some time to kind of what that means for an H-1B person, because you may have some extra, options available to you. So if you're on an H-1B visa, let's say, and you still have some additional time left in your 6 years, or maybe you're eligible for an extension, then you can port during your 60-day grace period. You can find a new employer. That new employer can file a change of a change of employer petition for you. And then you can start work. You can choose to wait until the petition is approved, or technically under the portability regulations, you can start working as soon as that petition was properly filed with USCIS. So in order to port, though, you must have some time remaining on your H-1B. So that can look like either time left on your initial, 6-year period, or if you are eligible for an H-1B extension beyond that 6-year period. And here we've talked about, when extensions may be available. So if you're in the green card process and a labor certification or I-140 was filed a year ago, or if an I-140 was approved and perhaps there's a backlog in your immigrant visa category. Let's say you have an EB-2 I-140 approval, but you can't file an adjustment of status because the category is backlogged, then you can utilize that to get an extension of your H-1B beyond the 6 years. Something you want to consider if you were going through the green card process with your employer is that they aren't required to withdraw the I-140 petition after employment is terminated. So this is a bit different from an H-1B. Let's say your H-1B petition was approved and then you got fired or you left the company. There's an actual requirement that employers have. They are required to inform USCIS of this change, but that's not the case for the I-140 petition. So timing is very important with the I-140 approval. If it's revoked or if it's withdrawn before 180 days have passed after the approval, the I-140 is going to be revoked. And then you can't use it as the basis for your future H-1B petition. So many employers, may be willing to work with you, and either not withdraw it, wait to withdraw it until that time frame has passed to allow you to take advantage of using that I-140 approval for future H-1B extensions. Another thing to consider on the H-1B is that although self-employment is not technically allowed in the sense that, there has to be an employer-employee relationship. So in that sense, self-employment is not allowed. However, there are things you can do to, basically if you have your own company, let's say you have a co-founder, or perhaps there's a board of directors, there's things that you can do to essentially create a structure to show that even though you are an owner, there is a bona fide employer-employee relationship and a legitimate job offer. So, you would though need to have that board of directors. There would need to be corporate documents that, truthfully and in good faith document that they would have the ability to remove you. They have the ability to hire, fire, assess your work, and control your work product. So that would all be very important. So if it was your own company, you'd have to be willing to essentially, as an employee, put those constraints in place so that there was a legitimate employer-employee relationship. Another thing to consider is that, let's say that, you only have 30 days left on your grace period. Putting all this in place very quickly might be difficult because you also need to show that there's sufficient specialty occupation work available for the 3 years. And you would need to show that the company has the ability to pay the prevailing wage for the position. So if somebody, if you're in a situation where a company is not even started, you don't have any funding, you don't have any ideas, this is likely not a good option for you. However, sometimes, people may have perhaps a company where they were a passive owner or were investing with a co-founder, or something that was already in the works, where there already is proof of client contracts, there's already perhaps proof of funding. That type of scenario is something we mention, as it is possible to, potentially apply for an H-1B with a company where you have an ownership stake as long as these other criteria are met. All right, so let's move to, away from just H-1Bs and talking about the option to change your status. So, the 60-day grace period, really gives you this opportunity to either, make your plans to depart the United States, or another thing you could do is you could file a petition to change your status, before the grace period is up. And, change of status could look many different ways. So one is you could change your status to another work visa. So the E2 visa is a great option for, entrepreneurs or business owners who are interested in developing and directing a company in the United States. This visa type does require that you make a substantial investment, and you have to be a national of a treaty country. So that can be tricky. Very often, people who are here on H-1Bs, perhaps they're, Indian nationals or Chinese nationals. Unfortunately, India and China are not treaty countries for E2 purposes. However, there are many, many treaty countries all over Europe and Asia and Africa. Certainly worth investigating, South America, Canada, Mexico, so lots and lots of countries are treaty countries. And so if you have an entrepreneurial outlook and you are interested in making a substantial investment to start up a company in the US, this could be a good option for you. Another, potential option, let's say you're somebody who has extraordinary ability in your field, you have sustained national or international acclaim. The O1A or O1B visa might be available to you. O1A is for athletics, sciences, and business. The O1B is for the arts and motion pictures. So that could be a potential option. That option is something you would really only want to consider if you have, a track record of awards and prizes. You've made some original contributions to your field. If your field is the type that, looks upon publications highly, you could look at that. If you're someone who has earned a high salary relative to others in your field, if you've worked for distinguished organizations in a lead or critical role. So there's, several criteria you need to meet. You need to meet at least 3 criteria out of 8 or 10 criteria for the O1A and O1B. And this is really going to be for people who are established in their fields and can show that track record of, of success, or for the O1B, distinction. But I think a good thing to keep in mind, particularly if you have been working in your field for a long time. Another thing to consider is the TN visa. So if you are a national of Canada or Mexico, in order to qualify for this visa, you have to have a job offer and a degree in a relevant field. So there's a particular list that's part of the US, Canada, Mexico agreement. And so, for example, accountant is on the list. So if you are an accountant and you have a degree in accounting, and you have been given a job offer for a company in the US to do accounting work, then you could get a TN visa. The benefit of the TN is that if you're Canadian, you can just go to a port of entry with that job offer letter and the proof of your, your degree. If you are a Mexican national, then you'll need to go to a US consulate. But generally, these visas can be quite straightforward. And if you do have a degree that is on the list, then when you have this nationality, then it can be a really great option for you. Another thing to consider is changing to dependent status. So some people perhaps may be here, maybe you and your spouse are both on an H-1B visa, and you haven't been able to find another job. So perhaps, but you don't want to leave the US, perhaps you could change your status to H4 on the basis of that, that family relationship. So that's always something to look at is, is your spouse in the US, what visa is your spouse on, and can you potentially switch to a dependent status? There's some dependent statuses that allow work. For example, if you're an E2 spouse or you're an L spouse, then you can work, and there's others that don't allow that. So if your spouse is here on a TN and you get a TD visa, that wouldn't permit you to work. If your spouse is here on an O1 visa and you get an O3 visa, that would not permit you to work. So always a good thing to consider, though, especially if your goal is just to stay in the US. Another thing to consider if your goal is to stay in the US is, did you want to go back to school? Perhaps you were here, you earned your bachelor's degree, you worked for a couple of years, but you always wanted to pursue a master's. You always wanted to pursue a PhD. That's something else that you could consider. Do you want to change your status in the US to start school. If you are interested in that option, it's also good to consider, though, that a change of status for students is taking a very, very long time, and you may be better served by planning to, go to a consulate abroad to get that F-1 visa stamp if you do have a particular time in which you want to start school. You could also transition to either B1 business visitor or B2 tourist status. Sometimes people feel, okay, I've been laid off, I'm going to leave the US, but I'd like to have some time to vacation before I leave. Or, I'm interested in potentially looking into E2 opportunities, but I don't have a plan yet. I'm not ready to make my investment yet. So those are reasons you could potentially change your status to B1 or B2. Similar to the student visa, B1 and B2 changes of status are taking a very, very long time. So it is something where, in all likelihood, if you apply to change your status and ask for 6 months in B2 tourist status, in all likelihood, you'll leave the United States before your before the B2 change of status is adjudicated. So it may ultimately be denied. That's okay. It's something that would mean that the time that you spent past your I-94 end date would be time out of status. It wouldn't prevent you from getting a visa in the future. It wouldn't be considered unlawful presence, which is something that can negatively impact your ability to re-enter the US. But it would be something that has to be disclosed on future visa applications. So just something to keep in mind when you're planning that changing to a student or visitor status, may not be the best option for you. But something to consider, particularly if, you're in a tight spot and you want to stay in the US and you don't want to make sure you're not accruing unlawful presence, you can file that petition and it puts you in a period of authorized stay and prevents you from accruing unlawful presence. All right, so let's also talk about, you can file for a change of status during this grace period, but you could also potentially file for an adjustment of status, depending on what options are available to you. So, we'll talk about some kind of family-based and employment-based petitions. So let's say that you're here and you are engaged to a US citizen, but you weren't planning to get married right away. So perhaps you move up that date of when you're planning to get married, and you get your marriage certificate and you file that petition, to adjust your status to a green card. That's one potential option. You could also consider self-employment green card options. So if you are, somebody again who, talking about the O1A and O1B standards, similar to that, but kind of a higher threshold would be the EB1A Extraordinary Ability Green Card. So the benefit of this is it doesn't require a separate employer. You yourself can self-petition. However, this visa is for people who have reached the very, very, very top of their field, who are, able to demonstrate that sustained national and international acclaim. The actual criteria are very similar to the O1A and the O1B in terms of the language of the regulations. However, the standard of evidence that you need to provide and the standard they apply when looking at it is much higher. So, people applying for this type of green card should be sure that they have a large amount of evidence that can support that they are somebody who has risen to the very, very top of their field, one of the few. So that means you would need experts in the field who are willing to attest to your skills, and then proof that you meet the other regulatory criteria, such as prizes or awards, original contributions, high salary, publications in major media, things like that. Another potential option is the EB2 National Interest Waiver. The benefit here, again, similar to the EB1A, it allows you to self-petition. So you don't need that outside employer to come and, and sponsor you. For the EB2, you need to show that you have either an advanced degree, so a master's degree or higher or equivalent, or that you have exceptional ability. So exceptional ability is kind of a lower standard than extraordinary ability. Once you meet that threshold requirement, then in order to get the national interest waiver, you have to show that you are engaging in a proposed endeavor that has substantial merit and national importance, that you yourself are well positioned to advance that endeavor, and that on balance it would be beneficial to the United States to waive the requirement of a labor certification. So for the national interest waiver, really a lot of the focus is going to be, so for the EB-1A, the focus is really on you as the individual. What claim have you, received? Have you risen to the very top of your field? For the national interest waiver, sometimes if somebody is very accomplished in their field, but doesn't feel they quite meet that EB-1A standard, however, they're working in an area of substantial merit and national importance, this can be a good option because, there is a focus on what you, the individual, have done, but it's much less rigorous than for the EB-1A. So the standard is, are you, in a position to advance the proposed endeavor. So let's say if you're an entrepreneur and you have a track record of success in this particular area, that could be, something you can utilize to potentially, get the national interest waiver. So that's another option to think about. Right now, unfortunately, the EB2 category, under which you would file the national interest waiver, is backlogged. So let's say that you were in a position where you were laid off and you wanted to go ahead and file for the national interest waiver. It wouldn't be possible at this moment to concurrently file for the green card application in the US, just because the EB2 category is right now backlogged as of, April 2023. However, there are times where the EB2 category is not backlogged for many countries, although generally for India and China that you are going to see backlogs. So another potential option is the EB-5 immigrant investor visa. So this is a visa, where you are going to need to invest, either $800,000 or $1,050,000. It's possible to do direct investments. It's possible to do a regional center. And you do have the ability, if you're in the US and able to make this investment, to concurrently file a green card application. So that's a potential benefit if you have that money, if you've wanted to invest, perhaps you have people that can gift you that money to invest, that's another thing to potentially consider. The EB-5 immigrant investor visa, though, for the funds, there is a very, very strict criteria that you show exactly where the money came from, and only certain things will qualify. So you do want to work very closely with an immigration lawyer if you're going this route to make sure that the source and trail of funds is documented appropriately, so you can meet the criteria. These petitions are also taking several years to be approved. So again, very important to kind of make sure that upfront you're getting it right, because you don't want to be waiting for several years and then find out later, that you didn't meet the criteria and the petition is denied. An important thing to keep in mind is that just filing an I-130 petition or an I-140 petition does not give you any status in the US. So let's say, for example, you're filing a national interest waiver petition. Because you could not file the I-485 right now because the category is backlogged, if you just file an I-140 during your grace period, that doesn't give you any ability to stay in the US. It's the filing of the I-485 adjustment of status petition that will actually give you that ability to remain beyond the, the I-94 expiration date. So that's just an important thing to keep in mind. I think sometimes people confuse that. They think that the filing of an I-130 or I-140 has some impact in terms of your ability to stay in the US, and it does not on its own.
And Kelly, what are the benefits of filing the I-485 if you do timely file that?
Sure. So if you do file that, a large benefit is you can stay in the United States. You're considered to be in an authorized period of stay, and you can concurrently file for work and travel authorization. Right now, the travel authorizations are very backlogged. They're taking, over a year in some places. The work authorization permits are a bit less backlogged. They're focusing on those a bit more. So those timelines are a bit more, maybe 5 to 8 months. So that is a large benefit you get, not only the ability to stay in the US, but you can apply for that work and travel authorization. And then once you receive approval on those petitions, you can work and travel while you wait for your green card application to be adjudicated. All right, so let's talk about, what happens if you're getting to the end of your grace period and none of these options are going to work for you. So if you have reached the end of that grace period, you want to depart the United States as much as possible. You want to avoid going over that grace period. You want to avoid overstaying any period on your I-94. If you overstay the I-94, end date, then that's when you start to accrue unlawful presence. If you accrue more than 180 days of unlawful presence, you can be barred from reentering the US for 3 years, or over a year, you can be barred for 10 years. So you really want to be, careful about, what you're doing in the US. And if you do have an I-94 that's ending soon, you want to make sure you depart before the I-94 end date. Something to keep in mind, for the H-1B, E3, and O-1 workers, there's your employer should pay your reasonable, transportation costs in the event you were laid off. If you weren't laid off, then they're not required to do that. You can also, from abroad, make a plan to re-enter the US. So let's say that you do have time left on your H-1B, but you just weren't able to find a new employer. So you weren't able to port, before you left. You can still, be sponsored for a new H-1B petition from abroad. It just means that you would have to go to the consulate and get that visa stamp in your passport before you could re-enter. So, if you are leaving in a position where you're going to have to leave the US, better to kind of depart, not have any status violations that you'll have to report on a new visa application, and then just continue to apply from abroad. And you could potentially, re-enter on, another type of work visa. So that's something also to keep in mind.
Perfect. Thank you, Kelly. So we have received a couple questions, and if anyone else has a question, this is your opportunity to please do send it in. We have a few minutes left. So Kelly, one of our participants has an approved I-140 and has 3 years left on their H-1B. They have been terminated on the H-1B, their employer. So their question is, what will happen to the H-1B and the green card if they're not able to find a job in 60 days? And do they need to find an employer who will file a new H-1B, or could it be treated as a transfer?
Sure. So we'll talk about the H-1B and the green card petition separately. So for the H-1B, it sounds like there's 3 years left. So that means that basically if you find a new employer, you can port. They would do a change of employer petition for you. If you don't find a new employer, then as I was just talking about, you could leave the United States. A new employer could hire you while you're abroad, and then you could come back, and work for that new employer utilizing the 3 years left, on your H-1B. So it's not, you don't have to go through the lottery again, just because you're outside the United States. You can still use that 3 years of time. Something for the green card petition is that, even though your I-140 is approved, it sounds like an I-485 wasn't filed. And so the I-140 approval, if it's not revoked within 180 days, could potentially be used to get you additional extensions on your H-1B in the future. But if you want to get a green card in the future, another company would basically have to start the green card process all over. So just having the I-140 approved could provide some benefits in terms of H-1B extensions. But if you want to pursue a green card in the future, you will need to get that another company to sponsor you for the green card.
Great. And the same participant mentions that they're a citizen of Canada and their spouse is in the US on an E2 visa, which raises another option for them, which is the E2 dependent status. They mentioned that, as you said, they have not filed the I-485. So I think the question here is, what options do open by virtue of the fact that the spouse is a Canadian national who's in the US on an E2 visa? And how might that affect the dual intent issue at play here?
Right. So I think that's, another option that's available to you if your spouse is on the E2 visa is you could go to the consulate, and get an E2 dependent visa. The benefit of this is if you enter the US, they should put you in E2S status on your I-94 for spouse. And that itself permits you to work. So there is that benefit available to you. You could also apply for a change of status from H-1B to E2, but that will take a very long time to get approved. Those petitions are taking months and months. So going to the consulate would potentially be faster. That being said, as Dustin, alluded to, there is something to consider in terms of intent, right? So the H-1B has dual intent. This means it allows you to, be in the US temporarily while also intending to apply for a green card. For the E2 does not specifically allow for this dual intent. For the E2, it has a low standard for, proving non-immigrant intent, but if you have an I-140 approved, it's something they could ask you about. What are your future plans? In terms of kind of, I don't want to lose my perm approval, unfortunately, if the employer has laid you off, you can continue to get a benefit from the I-140 approval if they haven't revoked it within 180 days. However, in terms of actually getting the green card, you would need to find a new employer who will sponsor you for the green card. So you do have a couple options. A benefit of the E2 spousal option is you can work anywhere. So it doesn't have those, it's a little bit more flexible than the H-1B. The downside is you could be asked about your I-140. That being said, if you're not working for that employer anymore, I think very unlikely that it would prevent you from getting an E2 spousal visa. And then if you're in the US as an E2 spouse, and let's say it takes you a while to find work, that's totally fine. You're allowed to stay here and you can choose to work or not work.
So that E2 spousal status really does open some options by virtue of the automatic work authorization.
Yeah.
Kelly, while you were answering that question, another question came in. This participant is currently in the US on an F1 student visa. An employer filed for an H-1B and they are on the wait list. As we know, the acceptance rate for H-1Bs this year was extremely low. So I'm sure there are a number of people in that situation. Is it possible to file for the EB-2 NIW while they're on that H-1B wait list and are currently on an F1 visa?
Right. So I'm not sure what you mean by being on a wait list. So there is not really, the way that it works in terms of the lottery is your employer would have filed for you in the H-1B lottery and they've already run the lottery and selections have already come back. So if you were not selected, then that means that, and it's very unlikely that they're going to run it. Hypothetically, could they run additional lotteries this year? Potentially, in 2021, they ran 2 extra lotteries, but it's very unlikely that they will. I'm not sure what's meant by wait list, but if you weren't selected at this point, then it likely means you are not selected. So is it possible to file for an EB-2, while you're in your grace period on your F1? What I'd say is that having a master's degree in the relevant field is just what we call the threshold requirement to be able to apply for an EB-2. In order to qualify for the national interest waiver, you need to show that you have a proposed endeavor in mind that has substantial merit and national importance, that you yourself are, well positioned to advance that endeavor, and that on balance, it would be beneficial to the U.S. to waive the requirement of labor certification and the job offer. So, what I recommend is if you do have an endeavor in mind and that endeavor relates to issues of substantial merit and national importance in the U.S., and you have a track record of success in this area, or you have demonstrable work experience in this area, it would be good to set up a consultation with an immigration lawyer to kind of talk through your resume, talk through your proposed endeavor, and determine if that's a potential option for you. So I think having a master's itself is not going to get you where you need to go for the national interest waiver. There's a much higher threshold you have to meet related to the endeavor that you plan to undertake in the United States.
Okay, and I think, Kelly, there is a follow-up question about starting a business while they wait, and that business would be a restaurant. I think we're veering into the national interest waiver visa. And what I would quickly say before passing it over to you, Kelly, is that we do have at least one, I think several full webinars on the national interest waiver, and they are on our YouTube channel. So do check those out. They're about 45 minutes each, a lot of great information on those, as well as setting up a consultation. But Kelly, if you have any additional thoughts, I'll pass it off to you.
Yeah, sure. I mean, I think that starting I echo what Dustin says about looking for those other resources. I think, starting a restaurant, that reads to me more like something that's appropriate under perhaps an E2 visa, an E2 investor visa, if you want to own a restaurant and invest in it and develop and direct it. I think, that's, definitely something that can happen for nationals of treaty countries. So that's something to potentially look into. I think that, national interest waivers are so specific to the endeavor, but if the endeavor is just, I'm going to own a restaurant that will exist and compete in the market with other restaurants, that's not the type of endeavor that's going to work for a national interest waiver, because it's really not connected to improving things in the industry, improving, creating mechanisms that are going to kind of advance, anything within a particular industry. So, that would be more appropriate for something like the E2 investor visa, where you want to actually just run a company in the United States.
Perfect. Well, Kelly, thank you very much for sharing your extensive experience in this area. And to our participants, thank you for taking the time and for sharing your questions. Hopefully, this webinar did give you a sense of, it's beneficial to pause, take a breath, really think about what your options are, because more often than not, there are options available, even if it's just submitting an application to extend or change your status to give you a little more time to assess what you want to do next. So thank you all. Please do keep an eye out for the email that we'll be sending momentarily. Have a great day, Kelly. Thank you again.
Thank you.